going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great night so far. Happy Friday. We made it. It's a holiday weekend. Not working in the office every day. I completely forgot Monday was a holiday until they started saying it in court. And it took me a second. I'm like, what? What holiday is in January? We don't have a holiday oh, yeah, we do. I didn't think about it. It wasn't automatic for me. Oh, man, I usually have those days counted down. Like, oh, we have 2 weeks till a 3-day weekend. I can't wait. All right. I'm done rambling. Okay, we're here to watch some court. Yes, we had a Rachel McDuffie sighting in Judge Washington's courtroom. I think this was Tuesday. And I was saving this for a slow court day, and oh my, today was slow. Today was one of the slowest court days since I've started my channel. It was pretty bad. But so tonight's perfect night for this clip. Now this is it's a hearing before a jury trial. It is all the attorneys got together and they're going over jury instructions. So that is the basis of this hearing. It gets heated, and Judge Washington's not having it from any of the attorneys. Let's see, we have APA McDuffie, then we have Mr. Mansour, and can't remember the other guy's name off the top of my head. I can just remember what he looks like. Anyways, but the defendant's not there. They waived his appearance. It's still, again, this gets interesting for a jury instruction here. It really does. Okay, I'm done rambling. Let's get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
The 14B District Court is now back in session. The court will call the case of the State of Michigan versus Terry Brewer, 24 FB 1224 FY.
APA Rachel McDuffie for the people.
Matthew Mansour, Assistant Public Defender, on behalf of Mr. Brewer.
Assistant Public Defender Davy Lebo, also on behalf of Mr.
All right, I don't know what's going on with StreamYard, but they keep changing my settings. Now we're back to this font when I bring up comments. Sometimes it's the square one, sometimes it's the bubble one. I have no idea why I keep changing. All right, I'm done. Get off my soapbox. Let's go.
Mr. Brewer, who is now.
All right, Mr. Brewer is not present because the court realized that we have to address all the issues for jury instructions prior to getting out to the 14A court on Friday. This court doesn't have a jury room for the next 10 months or a place to hold a trial. So therefore, we're here to address that issue, and Mr. Brewer is not present. If need be, we can place something additional on the record when he is present.
Heather!
On Friday, but I will be making the ruling today. I wanted to address the jury instructions and any other housekeeping matters that may come up prior to Friday. So let's start with the jury instructions. This is a domestic violence case. I understand that the standard DV instructions will be provided. Is that correct, counselors?
Yes, Your Honor, that is correct. I believe 17.2A, which is on both defense and prosecutors' jury instruction form.
Thank you. And then before Ms. McDuffie arrived, and while at the time the prosecutor Woods was here, you had mentioned that you wanted a special instruction. Which instruction is that you're requesting?
Yeah, BSBT. A jury, that's when a group of people comes in on their days off work or, out of their normal lives and sits in a little box and listens to a case. I know you don't know what that is because when it was your turn to have a jury trial, you ran. So I'm just explaining it to you. That's what it is.
Your Honor, specifically on the defense's jury instruction form at the end. It's before the offense and elements instructions 5.12, prosecutor's failure to produce a witness if applicable.
All right, so that's the one you were referring to.
Yes, Your Honor. That's the, yeah.
All right. Mhm.
And Your Honor, I don't know if you have the defense's jury instruction in front of you, but under the offense and element instructions, I don't know if 7.3A is a special instruction, but if it is, I would like to add that too.
Accident as a defense to specific intent.
Yeah, Your Honor, if applicable. I don't know where the testimony would go, but
All right, let's take them one at a time. So first of all, 5.12 states that you fill in the witness's name is a missing witness whose appearance was the responsibility of the prosecution. You may infer that this witness's testimony would have been unfavorable to the prosecution. That is what you're requesting to be added, correct?
correct, Your Honor.
Ms. McDuffie responds.
Thank you, Your Honor. So of course I would object to that particular instruction. This came up on a previous trial. Mr. Mansour, Mr. Lebo were not present, but the court and both parties spent quite a bit of time looking into some of the history of this particular instruction. In this case, we had multiple hearings. There are multiple motions and notices filed. The court made its ruling and the order has been signed. By the way, can I get a signed copy of that order at some point? I forgot to ask for that. So the court has already ruled that the evidence from the complaining witness in this case can come in her absence. I think we had an exception regarding potential reference to a firearm at one point that we were going to stipulate to, but aside from that, that this testimony is admissible and can come in. The instruction there refers to MCL 767.40A, which is the list of witnesses to disclose to opposing counsel, and the fact that if for some reason defense needs some assistance in locating and serving a witness, that they need to make that request to the prosecution and that we can then assist them in trying to locate that person. And so the basis of this is really the fact that there is somebody who obviously defense would want to cross-examine the prosecution failing to provide that requested assistance. And then the inference can be made that this person's testimony would have been unfavorable to our case. I don't think that that's quite the situation here. Again, we are producing evidence from this witness, and which has been deemed to be admissible for the purposes of this trial. So I don't believe that such an inference, I think, would be appropriate or relevant. I don't think this instruction, I think, is warranted.
All right, just to answer, well, I guess I'm not really answering any questions. I'm making statements. Yes, Ms. McDuffie, she keeps her camera off during this entire hearing. She has internet like mine, where my internet sucks. And when she's on video, her voice goes in and out for connectivity issues. So I'm guessing that's why she has it off. She doesn't really announce it, so I don't know. And this does get exciting. Otherwise, I wouldn't play it. I know jury instructions are generally boring. When I cover jury cases, I always cut them out because they're boring. Even when Sav sits do them, they're still boring. But this one gets contentious. Is that the word I'm looking for? It doesn't matter. You know what I'm saying. Okay. Let's see. We got to shout out Vic real quick. Vic, thank you so much for the 9 months. I appreciate it. I could, yeah, you could. I mean, that would, yeah. We'll just say yes to that. We'll leave it alone. But Vic, thank you so much for the 9 months. I appreciate it. Okay, let's go.
I'm reading the statute again. Give me one moment.
Mm-hmm.
Well, I think the reason it became an issue then is in the other case, and every case
David, she's not. One of the biggest problems with this case is it's a DV case, and they're taking it to jury trial. The victim decided not to go forward with this, and Miss McDuffie thinks there's enough evidence to go ahead and charge him anyways. So that's what a lot of this is based around, and that's what they're going to be arguing that here shortly. But yeah, the victim is not participating, so it makes DVs a little trickier to do.
Is separate. In this particular case, are you requesting assistance to try to get that witness there? I think what happened is the person actually in that other case withdrew their request for that statute because they were that instruction because they weren't actually seeking assistance to get the person there. Are you seeking assistance to try to get Ms. Thomas to this hearing today? I mean, on Friday?
No, Your Honor.
The statute does say that you have to request assistance before that it's not clearly written that way, but that's how I interpret that. You have to request assistance before you can try to request that statute can be used against the prosecution.
Your Honor, I would argue that in this case, that instruction or a similar instruction should be used, even if it is not squarely within the typical usage, because this is a case where the complaining witness is a witness the prosecution would normally have available. We know that that witness is a witness who would generally be available for court because she did appear a couple days ago in another matter. And we did have some jurors indicate that they may
What are
be
you
inclined
talking
to.
about? I don't know what you're talking about. What do you mean a couple of days ago in another matter?
Ms. Thomas was also the complaining witness in the McBride matter, Your Honor. That would have been yesterday.
Oh, that's the same person?
We realized that shortly after court, Your Honor.
Oh. Interesting. Well, why are you not requesting assistance? I'm not going to give this instruction unless you're requesting assistance to try to secure her. If you think that she has something favorable to say to you, then I think you should request the assistance to get her to come to court. I'm not giving that instruction or any other instruction regarding this unless you're requesting assistance to secure her.
Understood, Your Honor.
So I will issue an order for you and require that the prosecutor go out and serve her again to be here and show cause her at the whole 9 yards, if you want that.
I do not believe that's what we're requesting at this time, Your Honor.
All right. Then the motion for that particular instruction is denied.
Thank you. I would ask if the court would consider an instruction that the jury is not to consider the absence of complaining witness in and of itself evidence that the defendant did anything to prevent the complaining witness from appearing.
I think you can argue that I'm not given a specific instruction to that effect. There's no instruction that says that if you want to argue that, you can, but I'm not going to give an instruction to that effect.
Thank you, Your Honor.
See, I think that goes both ways. A juror is either going to think that something happened where the victim was afraid, or that she doesn't want to go forward because she doesn't want to go forward. Like it that can swing both ways. So bringing it up might actually be more harmful than good. Just ignoring it and not bringing it up might. I don't know. This is strategy.
What about Mr. Mansour is asking for? 1 second, let me get back there again. An instruction, accident as a defense.
Yes, Your Honor. I'm sorry. I was looking at the instruction, and I'm reading it. It says the defendant says that he or she is not guilty because she did not intend to state the specific intent required. The defendant says that his or her conduct was accidental. If the defendant did not intend to state the specific intent required, he or she is not guilty. The prosecutor must prove beyond a reasonable doubt that the defendant intended to state the specific intent required. I think, depending on how the trial goes, what the testimony shows, that instruction should be read to the jury, if applicable.
So you believe that there may be testimony that comes out that says that shows the defendant didn't intend to, I don't know, I think the allegation in this case was, I think it was hit or push.
I grabbed her by the shirt collar to like pulled her up. Well, the way that she described the context is a little bit different than the way he did. She said that he grabbed her by the shirt, kind of by the collar, and pulled her. And I think he also struck her in some way. I can't recall exactly what that was. He said it more as if he pulled on her shirt to say, you know, that he wanted her to listen to him.
Mm-hmm.
And Your Honor, that goes exactly to the intent aspect, which the last part that Ms. McDuffie just stated. He said it was for her to want to come talk to me. So if we are in trial and, you know, testimony comes out that, you know, what the intent really was falls along this line, I would like to have this instruction read.
How is that an accident, though?
Maybe not an accident, but, or okay, maybe it could be an accident. Maybe it was just, you know, I don't know how the testimony is going to go, but grabbing this person's shirt without concrete evidence showing that what his specific intent was, what he meant to do, should be played.
Ms. McDuffie?
All right. I'm going to try to recap this the best I can. It just kind of started. I know we're 15 minutes into it, but they're just getting into the meat of this case. This is a jury instruction hearing. They're having this before the trial. Generally, when I see jury trials, they'll have this, you know, they'll pick the jury and then they'll have this jury instructions before the jury comes out, and then they'll deliver the jury instructions. Now they're doing this today. Not today. This happened on Tuesday. Anyways, I don't know why I'm going into detail about that. Here's what the case is about. This is a DV case, domestic violence, and the victim chose not to participate. Ms. McDuffie is still going forward with the charges, which makes it rather difficult unless you have concrete evidence, which she believes she has, which is why she's doing it. And so we're just going through now a list of what they're allowed to tell the jurors and what they're not allowed to tell the jurors. So, well, at least the instruction before the trial starts. Okay, I think I caught up. And I didn't even say thank you to Biggin. Biggin, thank you so much for the raid. I went into my spiel about catching everybody up, and I didn't even say thank you. Biggin, thank you so much. I appreciate it. I can't wait to go back and watch the end of the last video you were playing. It looked like a really good one. And welcome to all the Biggin Raiders. I do appreciate you guys coming over. Now that we're caught up, let's go. Oh yeah, also, unfortunately, APA McDuffie is not on video. Her voice is there, but she doesn't turn her video on. Unfortunate, I know. We do miss her smile, but we still get her voice.
Our response is, I think, twofold. Number one, it would appear based on the language of this instruction that this assumes that Mr. Brewer is testifying, because I don't really see how we are giving an instruction that says the defendant says that he is not guilty because he did not intend. I don't know how that testimony comes from anybody.
I'm sorry, Ms. McDuffie. I don't mean to cut you, but I can't hear anything. I don't know about anybody else.
Nobody else can hear me?
I can barely hear you.
It's very faint.
Okay. You want me to try to leave and come back?
No, just speak up, please.
Okay. So one, it appears based on the language of this instruction that it would require Mr. Brewer's testimony. I don't see how we get to the defendant saying he is not guilty because he didn't intend to out of anybody else's testimony except for his. If he chooses to testify, that's up to him. But I'm just saying that first and foremost. I don't think that comes from even a cross exam in terms of this instruction being given. Second, the intent here is that he made contact that Ms. Thomas at that time did not want. So I don't know how that's an accident. He said that, you know, they're in this argument or whatever, and he grabs on her shirt. And I think right after that is when the deputy says, you realize that can be considered assault? And he says, yeah, or something like that. So there's the contact itself is no accident. It's about the contact was made and the fact that she didn't want it. I guess I'm not seeing how this really would come in.
All right. Well, as to the argument that he had to testify himself to be able to establish this particular defense. I don't believe that's true. I think there are ways in which it could be established. He just gets to use this to say that he's claiming that it's accidental. So I believe that I'm denying I don't agree with the prosecution with respect to that part of the argument. However, the issue of an accident under these circumstances, it's going to be very hard to prove. I'm not saying it's an impossibility, but I don't see, as I think through the facts of this case, a viable situation in which it's going to be shown that it's an accident. Now, he can argue whatever he wants to the jury with respect to the fact that he didn't have intent to cause her to be in fear or to cause her harm or whatever or injury or whatever you want to argue about that, but you can't say that it's an accident, the grabbing itself. It's the issue of if the defendant did not intend, whatever that specific intent is, that's separate than saying that it was accidental. So the specific intent issue and the accident issue are not necessarily one and same. It is just that the specific intent is also encompassed within the accident instruction here in 7.3a. You don't get it just because he gets to say or he wants to argue that he didn't have specific intent. You have to also show that this was accidental. Let's say, for instance, he tripped and fell and grabbed her shirt. That would be accidental, and that he didn't intend to cause her harm, and they would be one and the same. But in this particular case, if he intended to grab her shirt to try to get her attention, the grabbing itself is not an accident. So it's going to be very hard to show. I'm going to print out the instruction, but as I see it now, I don't see that it will come in. It will only, we can address whether or not it'll come in at the end of and close of proofs. Does that make?
All right, trying to find good places to pause because they'll go 10, 15 minutes without stopping. So this might be the last pause for a few minutes, but it's worth it. Legal Fiction, thank you so much for the 10 gifted memberships. I appreciate it. That's very generous of you. Welcome to the 10 new members. Thank you, Legal Fiction. 97 TJ, thank you for the super chat. Love some Rachel McDuffie. Yeah, no, we miss her. We miss her. And every time I play a video of her when she, makes these limited appearances, like I need to do some research to figure out where she went. Always forget to do it. Hopefully I'll remember this time. But TJ, thank you so much for the super chat. And Thorina for 1 year. Thorina, that is awesome. Thank you so much, Thorina. Thank you. Okay, let's go.
Makes sense to everybody. Does everybody understand?
Your Honor, I do understand. I can see. I'm sorry. Go ahead, Mr. Mansour.
No, go ahead.
I can see how it might come out, for example, from me playing Mr. Brewer's own statements. I guess if he had such a statement, which is not in there, I don't believe. My only worry about that, I guess, but this is an instruction given after trial. It's the part of the instruction that says, it says it twice. It says the defendant says he's not guilty because he didn't intend to, but then it says the defendant says that his concept.
Ms. McDuffie?
Yes.
I ruled that I don't think that defense has to come from his own words. So that's my ruling.
No, I understand. I'm not arguing that. I'm saying that my concern was that the jury might believe that he was supposed to have. I didn't want any confusion about the fact that he doesn't have to testify with them seeing this instruction saying that the defendant says that it was an accident. That was my concern.
Yeah.
So, but this comes after trial. So it won't. I don't think it'll matter because they'll see that he did or didn't by that point. That was what I was saying.
All right.
And I think in any event, if he does not testify, we would be requesting 3.3, which I think would resolve that concern. That's the standard defendant not testifying instruction, Your Honor.
All right. Thank you. That's always given if he doesn't testify. All right. Anything else that we need to address in terms of this trial on Friday morning?
I think there is. Go ahead.
Oh, there's a lot more. We're not even halfway through this video yet, and no one started yelling yet. And I did promise you yelling. It will happen.
Oh, I didn't say anything. I was going to mention the what Mr. Lebo talked about earlier about the complaining witness actually showing up to this court yesterday under a different name, Leslie McBride. She apparently got married to somebody we are representing, a different person, and we would like the court to consider taking judicial notice of the fact that Miss McBride, or Miss Thomas, wherever she goes by now, is readily available. She showed up to this court this week, and she made a victim impact statement. So, and even if like we need to,
Once again, do you need assistance with trying to get Miss McBride here?
no, Your Honor, I'm just saying, like, can we at least bring the fact up that she has shown up to court in the past, and she's not showing up today if she doesn't show up?
That it's not unusual for that to happen, Mr. Mansour. I'm not sure what your request is. I'm not gonna take judicial notice in the middle of a trial that she can show up. I mean, that I'm not
So-
sure what you're asking for.
Real quick, this is a great question. Why are there two public defenders? It could be a couple different reasons. Generally, it means they have two different cases. What I'm guessing is they both covered him at one point, because they kind of rotate and do different cases. So they might have both covered him at one point. So they both have a vested interest in this jury trial, or they just both want more jury trial experience. I don't know. They didn't really say it, but I do know that there's not multiple cases. At least I'm not going to say I know that, but it's a DV case, so I figured it's all one file. Maybe he has a separate case, and Mr. Lebo's on that case, and this case could impact that one. I don't know, but yeah, Mr. Lebo doesn't talk all that much, so just that's why I think he might just be hanging out to get jury trial experience. I don't know. While I'm paused though, Omni, thank you so much for becoming a member. I saw your message that it lapsed. So when that happens, tomorrow or the next day, you're gonna get a membership milestone, and it'll say whatever months you have. So you didn't lose your months. Let's just say that. But thank you so much, Omni. I appreciate it.
I was just asking if we could use that to let the jury know that the complaining witness had a
If you're
choice.
asking the witness that she was here, that's not gonna happen. How you get that information in, I'm not trying to prevent you from, Miss McDuffie.
Well, Your Honor, I understand what Mr. Mansour is asking for and why, but I guess I don't understand why at the same time. I know that she was.
I'm sorry, you need to get closer to the microphone again.
My face is like pressed against the screen too. I don't know what's going on with this microphone. The fact that she has appeared in another.
Maybe you should sign in and sign back out again. Sign out and sign back in again.
Will do. 1 second.
Well, that would have been a great place to pause it. Hopefully, it fixes the mic. I love how that happened right when Big and rated, and all you guys thought it was my volume. I was like, oh man, this makes me look bad. It should only take a second. She'll be right back. I need the Jeopardy music.
Oh, here she is.
Yep, there we go.
Is this any better?
Yes, it is.
Okay, good. Okay, let's see, where was I? So I think it's just not relevant. I think that the issue here, and quite frankly, if we wanted to go down this road, the reason she is not appearing for this trial is because she's afraid of him. And I didn't get into the
That's
PPO
your-
that Miss Thomas filed against me.
Miss McDuffie, how do you know that that's why she's doing that?
From the contact we had with her. And for the things that I didn't get into, which was the PPO that she had filed at the time of this incident. So it's I didn't get into all that. I didn't try to bring all that into trial, but she documented how afraid she was of him, which was in effect at this time. So it's Mr. Brewer. It's the fact that she's not here or not present on this case, and for some reason feels like she's safe enough to appear on another DV case with a different individual, I mean, that's not, I just don't feel like that's relevant at all, quite frankly. And I don't know that well, I don't know if that does any favors to the narrative that defense wants to project. The fact that she is not willing to come on this case, but is willing to, I think that might actually have the opposite effect. But in any case, I don't have anything further on it.
Well, I mean, I think it goes to their argument that she is an available witness, not an unavailable witness, and to the fact that I don't know whether a subpoena has been issued to have her to show up here. Has it been?
Well, I did not issue a subpoena because we had a ruling that stated that the testimony could come in. So, however, we did reach out to her. I didn't formally subpoena her. At this point, we have in previous, we might have previously, but in this case, I know that Ms. Wilson reached out and does not believe that she's going to appear. So we have the confirmation that she's not expected to appear.
So you want to just go to trial on a case where you don't even subpoena a witness?
I did not issue one because we already had a ruling that said that her testimony could come in. So I didn't issue one, but we still reached out to contact her for trial. I just didn't formally send one out.
Well, let me tell you this, and I'm going to look into that issue because I think you have to show the court that she's not available. You're not showing me right now that she's not available.
We have to make that showing for what, her testimony to come in under the.
Yes.
It does not require that for the ruling that the court made.
So you think that under this particular statute that you can just bring in this evidence, whether the person is available or not available, so you can just proceed without without giving the defense an opportunity to cross-examine people?
Well, first of all, there's multiple things, Your Honor. In terms of the defense, as the court has previously mentioned, the defense has every right to subpoena a witness that they want to see a trial, just as obviously we do. The request for assistance is because they're having trouble doing so. So defense can also can and could have attempted to subpoena Ms. Thomas if they were having issues. Yes, that's what it is.
I mean, I agree that may be true if you've already tried to subpoena that person and you're saying, and then you get a ruling. But you're telling me just because you got a ruling that you could bring in information that you now want to say you're not even going to attempt to bring that person to court.
Well, no, it's not a matter of now I want to say because there was a ruling. The question has always been, first of all, what is the nature of this testimony? Is it testimonial or not testimonial? So that ruling was made. This testimony was classified this way. And so it was ruled admissible by the court. And that was the court's ruling. Second, so that's one issue. Okay, so that took place. Second, Miss Wilson has reached out and determined that Miss Thomas is likely not her. Quite frankly, this was information that we had discussed off the record because of safety concerns. But since we're on the record, I guess it's too late now, and we're here. But we can approach if necessary. Mr. Brewer's not present, so I don't really know. I don't know. People like to record things and put them on YouTube. I don't know what we're discussing right now, what effect this may or may not have on her in the future. But essentially, Mrs. Thomas's status, her communication with us, I think, changed over the course of the second domestic violence case that she had come out in this courtroom. So there was a point where we were in touch with her, and then it became more and more clear that she was probably not going to appear on this particular case. Obviously, she has appeared on another matter a couple of times. Those matters have been kept almost completely separate, where Mr. Brewer, as far as I know, didn't even have any awareness that Ms. Thomas was in another relationship. And it was out of my concern for her safety and what he might do if he found that out, that those cases were being kept separate. As much as defense obviously wants to bring in the fact that she appeared on this other case, I mean, again, I don't think that's relevant, but they can, argue whatever the court allows them to argue. So the ruling is made on, yes, this testimony falls under this category. It is admissible because it is not a confrontational issue in terms of that particular testimony in those circumstances. I doubted that she was going to appear, obviously, given the state that she is in and that we're in right now. So it's not just because I got a ruling, I didn't even bother. That's not the case.
All right. So I'm gonna try to clear this up, and hopefully I'm right, or at least I'm in the ballpark. First question, MGT. No, they didn't have a falling out. Miss McDuffie is no longer the prosecutor for Judge Washington's courtroom, and I don't know why, but it's not because I don't think it's because they had a falling out. Um, Judge Washington was just doing her job. Miss McDuffie wants to bring in documentation where the victim said she was scared. That's why she's not there. But the problem with that is you're bringing in victims' statements when the defense can't cross-examine. So Miss McDuffie's trying to explain why she can do that. Is what's going on. But yeah, this is a tough one.
I'm not sure I'm hearing anything that changes my thought that you got a ruling and you just decided you're proceeding on what has been ruled as non-testimonial evidence without even attempting to bring the witness here. You haven't issued a subpoena. That still remains the same.
Well, I certainly would have if there was a requirement that we demonstrate that a witness was unavailable for any of the applicable statutes or exceptions that we filed to do this under. None of them have that requirement. As a matter of fact, let me see if I can bring it up shortly. I believe that let me see here. I think that the domestic violence hearsay statute specifically makes a reference to the fact that a witness is not applies whether they're available or not. Let's see.
Well, I can tell you that this makes me rethink their request for the 5.12. If the prosecution is not going to even make an attempt to try to get the person here, then I don't believe that they should have to try to make an attempt to get the person here. And maybe they should be given that particular instruction.
Okay, one moment. I'm looking for the available. Well, Your Honor, I mean, here's the thing, right? Like I said, the defense could have subpoenaed her as well. There has been no.
Yeah, they're not required to do anything. You are required. You are required to prove your case beyond a reasonable doubt. And if there's a witness that is available, you think that it's fair to just proceed with what has been ruled as non-testimonial evidence and not even attempt to try to bring that person here. I don't find that that's fair.
Well, Your Honor, that's exactly first of all, on some level, that's exactly the purpose of that ruling, is to determine what can come in with somebody being absent. But second, the issue of this statute,
an attempt by the prosecution to bring them here, I find that, yeah, you can do that. You can do it under any circumstance. But if then the defense says they want a ruling that the person may say something that's not favorable to you, and you haven't even attempted, then I think I get to look at that. So it's a unique situation because people don't generally even use this particular statute to try to proceed against people. But because you gave me the impression that she wasn't available, then I was thinking that this was the only route you had to go. You have another route and you're not even attempting it or an additional.
I'm sorry, Your Honor. I wasn't trying to interrupt you. That's not accurate. I've never given the court, I'm not pulling the rug out from under anyone. I've never given the court the impression that we have exhausted all these options and we can't locate her, we can't find her, that she's missing, that we can't bring her. Her unwillingness to participate in the case is why she was unavailable, as far as I know. But when we reviewed this statute, the basis of this statute, as the court actually brought up in that other trial, was that the jury instruction was previously completely rescinded, or I don't know what the word for it is, because there used to be a statutory requirement that the prosecution produce all rest just a witnesses at trial. And that was overturned in the case law because the prosecution actually does not have that obligation. This jury instruction was previously rescinded as well based on that. The only reason that this jury instruction still exists at all is because of the exception that it still would apply in a case where the defense made that request 10 days prior to trial to say, hey, we need help finding this person. They can get the court, as the court always says, you're willing to sign an order to get that person to court too. So if the defense wants somebody to be at trial, whether obviously the defense is on notice that we don't believe that this person is going to cooperate at some point because we had all these motion hearings. So the defense has been well aware that we don't expect her to appear. So that's the point where that request can come in. I mean, that's what happened at the other trial. Either you want this person there or you don't. If you're hoping that you're going to win at trial because we can't even go to trial because this person isn't there, that very often happens. But in the case where there's a ruling made that says this testimony can still come in, then it flips to, well, wait, we should be able to make them come here or tell the jury that they should have been here. And then I don't want them to actually come. I want the benefits of this both ways. I don't want them here. I don't want anybody to help me get them here, but I want the jury to hear that they should have been here, or you shouldn't believe what the prosecution says. But I don't want them. I just want that to be what the jury knows.
And
I was just going to ask if that includes me, but then I finished reading the rest of your sentence. 'Cause I'm always audio. I'm not video. And not always. Sometimes I get on video. Anyways, I was trying to avoid saying this because it's speculation and I don't really remember. But there was a case, one of the last cases McDuffie had in front of Judge Washington, and the defendant was acting cocky. I would really think it was this guy that they're talking about. And Miss McDuffie kind of went off on him and said, we are still going forward with this just because the victim is not cooperating anymore. We are not, dismissing this case. We have plenty of evidence. Like, she kind of went off on him. And I think it's this case. So I wonder if that's why she's pushing this, because that guy, acted cocky thinking that he was going to get away with this. But still, it kind of sounds like he might.
that's the way I see it. Okay, I heard
Mhm.
you. Anything else from the defense?
Your Honor, so I would just additionally note that this isn't a situation where the defense doesn't want the person here but wants to act like we want the person here. This is a situation where the prosecution has made a decision that they do not want the complaining witness there, that they're not going to make efforts to have the complaining witness testify in order to prove their case. And I think the jury is entitled to know that they may have had a reason for doing that. Additionally, I do believe the court has the discretion to give any instruction the court deems appropriate, whether or not it is strictly a standard instruction or not. So I do believe the court does have the authority and discretion to provide this instruction, even if it is not the typical usage of that instruction.
Thank you. All right. So the court is going to allow the instruction under these particular circumstances where it appears that the prosecution has not even made an attempt to subpoena the complaining witness to be present. I'll allow it. 5.12 will be given.
Thank you, Your Honor.
Anything else today?
I believe there is. Go ahead. Every time I keep trying to say that, somebody says something. Go ahead.
A little bit of it. There's still one more issue that they're about to start talking about now that's going to finish out the video. We still have about 15-20 minutes left, though, so it's an argument.
Apologies. You can go ahead, Mrs. McDuffie.
Deputy Paragi is still on military leave. Apparently, he's not returning until a couple months from now in April. So there is, I think, a hearsay exception or rule that would apply to his video being played. I have to locate it. I got asked by the court to appear for this hearing, of course, a couple minutes before we logged on today. So I don't have it pulled up right now, but there is, I have to find it. Basically, the fact that the OIC reviewed the same video, knows who that is, recognizes his voice, and knows that that's him. So I anticipate that coming up as well.
Can you put in context for me who Deputy, I think you said Paragi is again?
Yes. So their Deputy Vanderost was the OIC. He was with Deputy Clark, who was newer and I think maybe still in some sort of training mode at the time. Deputy Vanderos and Deputy Clark did the interview of primarily Miss Thomas and her son when they were in the home. And
yes.
Deputy Vanderos is the one that answered the door. Deputy Piragi is the one who took Mr. Brewer outdoors and
Okay.
spoke to him the majority of that time. At some point, all of them are together.
And he drove him to the bus station also?
I believe he may be the one that drove him, but I don't think that we have anything that would be used from that portion of the video.
So
I think
it's just the interview portion of the defendant that you're trying to get in?
I think it's a portion of the interview where they are outside talking by the tree while Deputy Vanderos and Clark are in the house.
All right. Response from the defense?
Your Honor, we're obviously going to object to that being introduced to evidence. I believe you specifically made a statement to both counsels at the last hearing or at the last motion hearing that there will be no exceptions if the prosecutor cannot produce their witnesses to this trial. And that is, we've known about this trial for a while now. We've had motion hearings. This has been set out for quite some time. It seems like one of the officers is not going to be able to make it, and you stated that you would not allow scheduling leeway regarding this. So I'm going to argue that that is hearsay without any exception. To allow an officer's body cam footage of an interview of the defendant should not be allowed, Your Honor, especially if he's not going to show up. I don't want the jury to just watch videos all day without witnesses actually being there to be able to get cross-examined.
All right. It sounds like, and Ms. McDuffie was not given any real notice of today's, nobody was, not just Ms. McDuffie, of today's, I thought we were just making a record of some limited things, but the housekeeping matters that are coming up now. So it sounds like we may need to reschedule some additional time so both parties can discuss with me very logically and legally the analysis of the hearsay rule as it would apply to this particular video. If she's not up to speed to be able to make that argument, and you don't actually hear what the hearsay exception is, so you can argue to me as to why it's not a hearsay exception. So I think that I'd like for both parties to come up to speed on that and give me a little bit of an advance notice of what hearsay exception you're referring to, Ms. McDuffie, so that Mr. Mansour can know what that exception is, and I can have a look at it to see if I think it applies or if I don't think it applies. Does that make sense to everybody?
Yes, that's fine. And let me just clarify, I'm not asking for any sort of date accommodation. Obviously, you're set for trial Friday and the trial's going on Friday. It's number one, just a matter of Mr. Brewer's own testimony coming in. And so in terms of the deputy being on the other half of that conversation, it's really just about that. Because I think Mr. Brewer also has a ruling with his testimony, or his not testimony, rather
his testimony, his statements would be allowed in as a party opponent. So that's not really the issue. The issue is the other part of that.
Right.
So whether or not the whole thing can come in and whether it can be authenticated, those are the issues that we have. The authentication, and then and I don't know if the questions are hearsay. So that's the part that we need to deal with. Just like a police report is hearsay, I believe that this particular video would be hearsay unless we have those exceptions. So I'll give you time.
Yeah, then that's why I kind of think that I was right about my earlier comment where she felt insulted by the defendant, so she's pushing this case forward. I don't know that to be true. It's just speculation on my part. I can't even confirm that it was the same case. I just remember her going off on a defendant and telling him that she's taking this to trial, even though the victim's not participating. And it's really hard. It's going to be an uphill battle for her, and she made the decision to take it to trial. So they're going. Or she made the decision not to dismiss the case. So yeah, it's just she's trying. She's trying her best. It's just it's hard.
To research that, and we can set a time to do further arguments on that. And I'd like to do it obviously as quickly as possible so that we all know and can get prepared for trial.
Yes, Your Honor. And to be
Well said,
specific,
Barry. Well said.
this is almost phrased at Miss McDuffie too. It with Mr. Paragi's absence, the people are intending to use his body cam footage in his absence. Is that what we are? And then the statements that are coming from the body cam, is that what we're doing?
That's what the request is, correct?
Okay. All right.
That, and am I correct, Ms. McDuffie?
Yeah, that's the same footage we were planning to use the whole time. Basically with Mr. Brewer's interview with him. It's just the fact that we learned that he's not returning from military leave. So just as it returns to any of his statements, basically the questions being asked in the video from him, which would be authenticated through, and so just to let defense know, that authentication would take place through the other deputies being familiar with him, with the fact that that video is part of this case, having reviewed it as the OIC, recognizing Deputy Paragi's voice. I can point to the specific numbers and codes and everything for that once I look it up and get it handy. But basically admitting, basically no exclusion of Deputy Paragi's questions being asked with his absence under those.
All right, real quick. Yeah, I like him. I like him. I don't remember if I said he's a really good attorney, or I just said he's a good attorney. I think he is, but that's just my opinion. He could still be green. Like I'm not saying you're wrong, and I'm not saying I'm right. It's just an opinion. But my point that I made about Mansour was that Lebo and Mansour are just a giant step above Miss White that used to be there. And I didn't really have a problem with her. She just never seemed ready, and she was just never prepared. So I think it's just refreshing to see these two guys who come in and they actually do the job really well. They're prepared. They're ready to go. They fight for their clients, and yeah. So I guess I'm defending my argument. Yeah, I like them. I do.
All right. Any other housekeeping matters?
Just one, Your Honor, which is Ms. McDuffie really recently mentioned the statement that one of the officers in speaking to Mr. Brewer that that could be considered an assault, don't you, or something to that effect. We'd ask that that statement be excluded as it calls for as it is a statement of a legal conclusion.
Ms. McDuffie?
That's not testimony from the officer during trial that calls for a conclusion. That's something that he said to them on the scene. So I don't think that extends to any statements made out in the field in terms of what conversation takes place. But that can, Mr. Lebo, I guess I'm not really clear on what the basis for the exclusion would be in terms of what that rule is, but we can include that in the arguments we're going to submit to the court along with the rest, I would think.
Well, the basis for the exclusion is that it is a statement that would be proposed for introduction that is a statement of a legal conclusion. This is on assault by a person who's not qualified to make that legal conclusion.
But no conclusions. The questions asked and Mr. Brewer answered one way or another, but I don't think there isn't actually a conclusion made by the deputy asking the question.
I think that the conclusion is, just so that we're clear, the court believes that the conclusion is encompassed in the statement that that can be considered an assault. So it is a legal conclusion. The question is whether or not it can be played to the jury or not. So he's saying it can't be played because it's a legal conclusion, and you need to be able to argue, and I'll give you time to look that up as to why it can be played, although it's a legal conclusion. So I'll give you time to look at that issue, but I believe that the statement itself the question itself includes the conclusion that it's an assaultive behavior.
Okay, if Mr. Lebo would like to I want to be sure I'm referencing the correct thing. So if he's referring to a specific rule that prevents that from trial, whether it's a rule of evidence or something, let me know, because I want to make sure I answer exactly what he is targeting.
I think it's very well established that a witness cannot testify to a legal conclusion, and that testimony cannot produce a call for legal conclusion because that is the exclusive province of the court.
I understand what you're saying, Mr. Lebo. I'm saying it comes from a source. There's a lot of topics that cross over different rules of evidence, case law, things like that. I'm just saying, if you have something, send it. If not, that's fine.
Mhm. All right, so we dealt with 5.12, 7.3A, and then there was another issue in between this legal conclusion. What was that again?
Oh, Deputy Paragi's testimony?
Oh, yes. Paragi video. Okay, thank you.
So I can provide a citation, and that would be People v. Heft 299 Mich. App 69 2012. A witness may not opine about the defendant's guilt or innocence in a criminal case. I believe that would be at page 81.
Okay, that's
Can
what
you
I
give me
thought.
the site? Can you give me the site again?
Yes, Your Honor, 299 Mich. App 69 81 2012.
299 Mich. at 61?
69, Your Honor.
69. Thank you.
Yes.
All right, anything else?
Let's see here.
And Your Honor, that does further cite to People v. Fonville 291 Mich. App 363 at 384 2011.
I think that's the one I'm familiar with, Fonville. And
Yes,
give me
I
that.
think I may have been citing the site of a site.
All right, can you give me that one again?
Yes, Your Honor, that was 291 Mich. App 363. And let me just find the page number for you, Your Honor.
That's okay. I usually try to read the whole thing so I can have a context. Thank you.
Thank you.
All right. Any other housekeeping matters?
Let's see here. So there are, well, I guess just in terms of, I'm try to get this resolved as soon as possible before Friday.
Oh,
So-
there you go. You're gone again. Oh, you're back. Just
Okay.
start over.
I understand we want to get these things resolved as soon as possible before Friday, and there are requests from both sides and arguments from both sides. So what are we looking at in terms of another, in terms of when we can meet to get the rulings on all of these?
Unfortunately, tomorrow will not work at all. I get out of my docket and go straight into a landlord tenant docket, which takes all evening. I think I have 60 some odd cases on. So it will probably not be until Thursday. How many cases on Thursday afternoon? All right, maybe 3:15 on Thursday. Does that work with your calendars?
Let me check one moment.
Well, we'll be with you, Your Honor, so it works with us.
I think 3:15 should be fine for me.
Okay. Do you need a little later? I can do 3:30.
No, I think that's fine. I think I should be done hopefully before then. I'm assuming Zoom.
Yes, so
Okay.
3:15 on Thursday it is.
And Your Honor, as a less
Ah, man. They had that yesterday. She wasn't. Yeah, that wasn't on YouTube. That's unfortunate. We would have had a quick follow up to this. There's only, let's see, what do we have? There's only about a minute left of this, so I'm gonna let the rest of this play out, guys. While it's playing, I am gonna look for someone to raid. Not gonna lie, it's probably gonna be Lone Wolf. So yeah, You guys are awesome. Thank you so much for hanging out with me tonight. I know this wasn't the typical drama-ridden videos that I usually play. Um, I love a good legal battle, and Miss McDuffie is awesome. So I wanted to share it, and I hope you enjoyed it. It seems like most of you did. I didn't get the giant drop in attendance during the stream, so seems like most of you did. Anyways, thank you all for hanging out with me. Thank you, Biggin, for the raid, the super chats, the gifted memberships, the membership milestones. You guys are awesome. If yeah, like I said, we're probably gonna be raiding Lone Wolf. If I don't raid Lone Wolf, I'll pause it one more time to tell you where we're going, but it's most likely gonna be Lone Wolf. So make sure you go over there and harass him. And you know what? Go ahead and tell him how much better of a streamer I am than he is. He loves it when we say that to him. It's an inside joke. It's a joke. We tease each other all the time. So it's not me being cocky. He's just making fun of him because his channel's 3 times the size of mine. So I'm allowed to make fun of him. All right, you guys are awesome. Oh yeah, real quick. Tomorrow's Saturday. I'm off tomorrow. Tomorrow night is date night, so I will see you guys on Sunday. Don't do anything dumb. It is a holiday weekend. For those of you that have 3-day weekends, please be safe. Get an Uber. I will cover you. I promise I will. And I will jump up and down and say that I know you. So don't do anything dumb. All right. You guys are awesome. Until next time. Bye.
Contentious housekeeping matter. Do you know which courtroom we're going to be in on Friday?
B.
Thank you.
Any else? Any other less contentious housekeeping matters that we can have?
Let me just rack my brain really quick before we log off here. I don't think so. We will just I'll just submit everything. Let's see here. It's Tuesday, right?
Correct.
Okay. I'll try to get everything in tomorrow at some point.
Nothing else from anybody else, correct? All right. I'll see you all on Thursday. Thank you.
All right. Thank you.
Bye-bye.